SwayamPrabha. Digital India. Educated India.
Welcome students, welcome to the Transfer of Property Act course in lecture number 13. Myself Dr. Amrendra Kumar Ajit, Assistant Professor, Faculty of Law, University of Delhi. Today I am going to discuss mortgage and its kind. Prior I have discussed already sale and rights and liabilities of sellers and buyers. In this lecture, I will mainly discuss mortgage and its kind. Mortgage is also a kind of transfer of immovable property, but it is not like sale. In sale, we have seen that there is a complete transfer of ownership and buyer will take the complete right of owner. That means it is a absolute transfer with all rights in immovable property, whereas in case of mortgage it is not. Mortgage, it is a kind of security for debt. That means any person want to take debt or loan, in lieu of that he want to keep immovable property as a surety, and this process is known as mortgage in colloquial language, also in legal language. So, if you will go through the chapter 4 of Transfer of Property Act, which discuss is from this 58, section 58 to 104. And section 58 particularly discuss about the mortgage and its kind. Okay. The whole chapter discusses about mortgages of immovable property and charges. So, come to the section 58. So, section 58 is a long section which talks about not only the mortgage, but it also defined mortgage money, mortgager, mortgagee and different kinds of mortgage. So, first of all I will start with definition of mortgage, which is given in 58A, which says that a mortgage is a transfer of an interest in a specific immovable property for the purpose of securing the payment of money advanced or to be advanced by way of loan, the existing or future debt, or the performance of an engagement which may give rise to a pecuniary liability. Okay. So, this is mainly a kind of transfer of interest for the purpose of securing the loan. Okay. Here transferor is called as mortgager and the transferee is called as mortgagee. Okay. And the principal money and interest of which the payment is secured, that is called mortgage money. Okay. And the instrument or deed through which this transfer is done or effected, that is called mortgage deed. So, under section 58, if you will go through essentials and all after breaking it, then we used to find that mortgage is a kind of transfer of interest in some specific immovable property for the purpose of securing first payment of money advanced or to be advanced as a loan for any existing or future debt also, and performance of an engagement which may result into the pecuniary liability. Okay. So, if you will go through this, then it is a kind of transfer of interest in some specific immovable property. So, any mortgage, whatever the kind, okay, all mortgages used to secure loan, okay, and it is the security form that when the loan will not be paid, then the mortgagee, that means the person who has given the loan and took the mortgage, will have right to sell that property. Okay. So, it is a kind of security that okay, if something happened in future and loan money is not going to be returned, in that case it will work. So, the ownership of property in mortgage always remain in the hand of mortgager. It is not transfer at all. Okay. Whereas, in sale we have seen that there was a transfer of ownership. Okay. But some of his interest in the properties are transferred to the creditors who has given the loan. Okay. So, it is a kind of security of the creditors. It is very well founded principle and under section 58 that, and it has been also said in case of Gopal versus Purushottam by Justice Mahamood about this 58 of Transfer of Property Act, that the mortgage as understood in this country cannot be defined better than by the definition adopted by the legislature in section 58 of the Transfer of Property Act. Okay. That the definition has not in any way altered the law, but on the contrary has formulated in clear language the notion of mortgage as understood by all writers of textbooks on mortgage. Every word of the definition is borne out by the decisions of Indian Court of Justice. Okay. This is very important because the mortgage, how it has been incorporated in section 58, it reflects that how we have perceived mortgage in Indian context since long time, and the same way the judicial pronouncement how it has been developed later on, that all has been incorporated in this definition. So, it is said that in a mortgage, the right in the property created by transfer is accessory to the rights to recover the debt. This is very essential. It is a accessory right to recover the right to recover the debt. Okay. Property created by transfer is accessory to the right to recover the debt. Okay. That means, this mortgage give a right in the property to the mortgagee that if debt has been not recovered, then you can sell it in that way. So, debt subsists in a mortgage, but the transaction by which the debt is extinguished is not a mortgage, but a sale. Okay. Debt subsists in a mortgage, but the transaction by which the debt is extinguished is not a mortgage, but sale. That means, this property was mortgaged to A. So, A is mortgager, sorry, A is mortgagee because B has mortgaged, sorry, this it has been mortgaged by B. Okay. So, B has mortgaged this property X to A, then A and A has given suppose 5,000 rupees loan to B. Okay. So, here are two rights. One is A has a right to claim 5,000 from B, okay, 5,000 from B. A has a right, and this right has a this accessory right is that if it will be not paid, then this X can be used for recovery of this 5,000 rupees. So, there are two rights here, but whenever he will recover 5,000 from X, then it will be not a mortgage, it will be sale. A will sell the X property and will take 5,000 rupees from that with interest. Suppose interest is 2,000 rupees. So, total it will take 7,000 rupees, okay, and then it will 7,000 rupees it will take, and suppose property was sold into 20,000 rupees. So, 13,000 rupees will be returned to B. So, in case of Nidha Shah versus Murlidhar in 1903, very old case it is, the deed was purported to be a deed of mortgage with possession of certain villages for a period of 14 years. The deed provided that at the expiry of the term, mortgagors were to come into possession of the mortgage village without settlement of accounts, and that the mortgagee should then have no power in respect of the said estate, but should return the mortgage deed to the mortgagors without their repaying mortgage money. Okay. This was a unique kind of deed. Now, you can see here the deed provided at expiry of the term that the mortgagors were to come into possession of the mortgage village. That means, suppose here number of A, B, C, D were their mortgager, and after certain years it has been said that this will come property to the again mortgager, okay, come to possession of the mortgage village without settlement of account, that means loan, whether it is clear or not, it is going to come to the mortgager, and the mortgagees should then have no power in respect of the said estate, but should return the mortgage deed to the mortgager without their repaying the mortgage money. So, whether it will be a mortgage or not. Okay. So, mortgagee refused to return such villages on the ground that he had not received the full number of village and had not been able to recoup himself. The Privy Council said that the deed was not a security for the payment of any money. Deed was not a security, because it was not in the form of security. It has been said that okay, keep in and then return back after expiry of the period, and that the transaction was not a mortgage, but a grant of land for a fixed term free of rent. Okay. So, the suit was not on contract, but on title, and mortgagors were entitled to recover possession. That means, the person who has given those villages to the mortgagee, okay, and it has been said that after certain period you will return it without the settlement of account and all. So, court said that it was not a kind of mortgage, because this property was not kept as a surety for the against the loan, and when it was not a surety against the loan, in that case it will be not treated as mortgage. It was merely a transfer of land for a fixed term without rent. Okay. Now, element of mortgage. Element of mortgage is first transfer of interest, limited interest. Interest transfer must be specific to the movable property, and transfer must be made to secure loan of money or debt. Okay. So, first of all, transfer of interest. What is the transfer of interest? So, this transfer of interest, it is as one says that it is a transfer of limited interest in the property. Limited interest in that means, I have taken loan, mortgagee will take benefit from this loan benefit, or it has a surety that if I have not paid the whole amount with interest, then he will use this property to clear his loan, and he will sell it and he will take the amount. So, mortgage debt is not a kind of actionable claim. Mortgage is not an actionable claim. Actionable claim I will discuss later in another lecture itself, because it is a one module. Then it is only a transfer of an interest in an immovable property. It is different from the sale, because in sale there is a complete transfer. In case of mortgage, there is a limited transfer. Interest is given by the mortgagor to the mortgagee, and the type of interest is transferred to the mortgagee decides the kind of mortgage. That is very important. That is, what type of interest has been transferred, accordingly mortgage is categorized. Okay. So, without transfer of an interest, there is no question of there being a mortgage within the meaning of 58A. So, there must be certain transfer of interest. If interest is not transferred, then it will be not treated as mortgage. So, one example is given where the loan was taken from a bank and the borrower undertook to create a mortgage by deposit of the title deeds of his land. The Supreme Court said that no mortgage was created by such undertaking. Okay. Why? The reason is very simple. If you will read the line, the loan was taken from a bank and the borrower undertook to create. This undertook to create a mortgage. That means, mortgage was not created, only the promise was created that I will do mortgage. Okay. And the bank has given loan on that promise itself. That means, by deposit, so it has been said that the Supreme Court said that by promise only you have released the loan, and promise was what? That I will do the mortgage by depositing title deeds in future, and without taking the title deed, without keeping the possession of the title deed as a surety, it has been released, loan was released. So, court said that it was not a mortgage at all. A mere undertaking to create a mortgage is not sufficient in itself to create an interest in immovable property. So, promise for making mortgage or promise for doing the mortgage in future will not create any kind of interest. Just like you can remember that the contract to sell and the sell itself. Okay. So, in contract to sell there is a no sale at all. So, there is only a kind of promise that we will do accordingly. Same here in case of mortgage, if someone is promising that I will do, but the best part is that here, that if the creditor is giving loan, it is not only the mere promise that it has been given by the this mortgagor. Mortgagee is saying mortgage is already done. That means, he has already released loan. Mortgagor has not deposited title. It will be not said that the interest has been transferred. Okay. So, mortgage is a transfer of interest and its credit as a right in rem. Mortgage is a transfer of an interest, and whatever interest, because it is a partial interest. So, whatever interest is going to be transferred in the mortgage, that is right in rem, because the mortgagor will have right over those interests which has been transferred against the whole world. But mere agreement to create a mortgage does not create any interest in the mortgage property. Okay. Now, come to the element of second element of mortgage, that is a specific immovable property. What is a specific immovable property? That interest created by mortgage with respect to a specific property. That means, it cannot be vague. Okay. That means, a property situated in that taluka has been kept as a mortgage, it cannot be. That means, plot number, this khata number, all these things must be clear that which property is going to be kept as mortgage. Okay. So, mortgage deed, the property must be defined specifically and not in general term. General term should not be used with respect to property. Okay. That all land situated there, yeah, part of the land of this or that. No, a specific which land and sometime in detail also. That means, at least property must be identified, that which property has been kept under the mortgage. A life insurance policy has been not treated as a subject matter of mortgage, because it is not a property. Then consideration. Okay, mortgage must be supported by consideration, because it is also a kind of contract, and this contract consideration is what? It is in the amount of loan. So, consideration may be either money advanced or to be advanced by way of loan. That means, prospective loan may be also done under the mortgage, or this past loan may be also protected under the mortgage, and present, that means, if present loan, that means which I am going to take just now, that also be go under the mortgage if I am going to give the interest in the immovable property. So, transfer which is made by way of discharging a debt is not a mortgage. Made by way of discharging a debt, transfer which is made by way of discharging a debt is not a mortgage. Okay. Discharging a debt means what? In mortgage, what is important thing is that it is the surety. That means, loan amount must exist, okay, against that property, and you are keeping this property against that loan amount itself. But once you are discharging the property, discharging the loan, then that transfer will be not amounted as money. Suppose there was a 10 lakh rupees, 10 lakh rupees a loan, over that after interest it is 18 lakh, and now hardly it has been paid 7 lakh, okay, 7 lakh. So, 11 lakhs are remaining. Now, I want to settle it, and I am giving a plot or a flat of 11 lakh rupees to the creditor. Okay. So, after giving this creditor 11 lakh rupees value of plot or flat, now my loan will be 0. So, this is discharging the loan, that means completing the loan, and when the loan is going to be completed by giving immovable property, then it will not fall under the mortgage, because this loan has been closed, then this is not a surety. Okay. So, discharging of loan is completely different matter, it will not fall under the category of mortgage. Okay. Where the mortgage has already advanced money, okay, where the mortgage has already advanced money, the mortgagor may execute a deed of mortgage as surety for its payment. Okay. Already there was a loan, and now mortgage has been done. Mortgagor may also execute a mortgage deed before he gets full amount from the mortgagee. Mortgagor may also execute a mortgage deed before he gets full amount from the mortgagee. That is, mortgage deed may be made even before the getting the full amount of the loan. The transaction of mortgage does not become ineffective merely because the mortgage could not advance the money on the date of execution of the deed. Okay. Transaction of mortgage will not become ineffective on the ground that the mortgagee could not advance money on the date of execution of the deed. He may give you later on also to the mortgagor. Okay. Now, come to the kinds of mortgage. It is also very important, and I told you already, according to the transfer of the different types of interest, there is a categorization of mortgage. So, section 58 discuss about 6 type of mortgage, and first is simple mortgage, second is mortgage by conditional sale, third is usufructuary mortgage, fourth is English mortgage, fifth is mortgage by deposit of the title deeds, and sixth is anomalous mortgage. Okay. So, now I am going to discuss one by one all these. First, come to the simple mortgage. Name is simple mortgage. So, mortgage is also in its simple meaning. Okay. Defined under 58B. What it says? That where without delivering possession of the property, the mortgager bind himself personally to pay the mortgage money and agrees that in the event of his failing to pay according to his contract, the mortgagee shall have a right to cause the mortgaged property to be sold and the proceeds of the sale to be applied in payment of the mortgage money. The transaction is called a simple mortgage and mortgagee is called simple mortgagee. Okay. So, simple mortgagee or simple mortgage itself says that there is promise on the part of the mortgager that I need this amount of loan, against this loan this is the property, and here property is not going to be transferred. Okay. That means ownership and possession of the property will remain in the hand of the mortgager. Okay. But he has already given promise that if I will not pay on time this amount of money, then the mortgagee will have right to take money through this property. Okay. So, then it is simple mortgage, it has been said. So, here mortgager bind himself personally to pay mortgage money, okay, without delivering possession, and here there is no requirement to give the title deed also. Okay. Title deed, only thing is that within it must be mentioned within the mortgage deed. Okay. Mortgage by title deed is something different, that is another kind of mortgage. Okay. So, here it should not be supposed that this simple mortgage is one saying that okay, property his possession has not been given, but the documents related to the property has been given. That is not also the case here. Here it is simply on the agreement itself, it will be mentioned that I am taking this loan, this amount of loan, willing to pay this up to this date and this year, and if I will not pay this property must be specified, because in any case in any kind of mortgage, property may not be ambiguous. So, it will be a specific immovable property must be mentioned in the mortgage deed, and mortgage deed will say that okay, that if this property, this loan is not going to be paid on time, then the mortgager will have right against the loan amount, okay, by using this property. So, this is called a simple mortgage and mortgagee is called as a simple mortgagee. Okay. So, in the simple mortgage, mortgagee has twofold security. Mortgagee, that means the person who has given the loan. A person who is taking the loan, he is the mortgager, because he is keeping property to the mortgagee, and mortgagee is the loan giver, that is the person who is providing the loan and who will have right later on against that property. So, it says that the mortgagee has twofold security. First, that mortgager takes personal obligation, and second, that the property which may be sold in case of failure of the mortgager to pay. So, first, that the mortgager has given a personal promise, if that is not going to be fulfilled, then there will be sale of the mortgage property. Okay. And this property will be called as a mortgage property. So, do not think that something should go into the hand of the mortgagee, nothing is going in this case, not the possession is going, not the title deed is going. What is going? That only he is making an agreement with the mortgager, okay, with the mortgager, that this amount should be returned up to this time, otherwise this will be sold. Okay. So, when the mortgager fails to back pay the money, mortgagee will move the court for a decree to sell the property. On the basis of that mortgage deed, he will move to the court, and as soon as the decree is awarded, he may proceed to sell the property. Okay. Then the mortgager will have to give the documents related to that, and through auction it can be sold. The proceeds of the sale will be used to pay off his debt along with the interest and the balance amount, if any, will have to be paid back to the mortgagor, okay, under the simple mortgage. Next is mortgage by conditional sale. This is also very important mortgage, that it says that there is a certain condition of sale within the mortgage itself. So, what it says, first of all we will see about it, section 58C. It says that where the mortgagor ostensibly sells the mortgage property, where the mortgagor ostensibly sells, okay, ostensibly means here pretends to sell the property, but it is not actual sale. It looks like that property has been sold, but it is actually not sold. So, the mortgagor ostensibly sell the mortgage property on the condition that on default of the payment, the mortgage money on a certain date, the sale shall become absolute. That means, once the money will not be paid, then what the sale is looks like will become the real sale or exact sale, or on condition that such payment being made, the sale shall become void, or if the total amount has been paid by the mortgagor to the mortgagee before that date, then that conditional sale will become void. That means, now property will come back to the mortgagor, or the condition that on the such payment being made, the buyer shall transfer the property to the seller, or within such case also that if the whole amount is going to be paid to the buyer, such payment is being made, the buyer shall transfer, that the mortgagor shall transfer that property to the seller. So, that is fall under the category of conditional sale. So, conditional sale here is that sale type of situation has been already created through the mortgage. That means, you can say here that more or less all the formalities of sale has been done in the form of mortgage, but ownership has not been transferred, or sometime it may happen that it is so actually done that later on he is saying that once he will pay all amount, then he will have to, the buyer will have to retransfer that property to the seller. Okay. Buyer will transfer the property to the seller, okay, but it is not actually sale. So, the transaction is called a mortgage by conditional sale, and the mortgagee is called as the mortgagee by conditional sale, provided that no such transaction shall be deemed to be mortgage unless condition is embodied in the document which effect or purports to effect the sale. That means, under this conditional sale mortgage, it will say that no such transaction shall be deemed to be a mortgage unless the condition is embodied in the documents. So, condition, what condition? These condition, these any condition, because here or has been used. Okay. So, any condition 1, 2, 3 or 4 must be mentioned in the document, then only it will fall under the category of conditional sale. Then there is a requirement that it should be a sale not by mortgage deed, which would become sale after a particular period in eventuality of non-payment of mortgage money. Okay. There is a requirement that it should be a sale not by a mortgage deed. Okay. It should be a sale not by mortgage deed, which would become a sale after a particular period in eventuality of non-payment of mortgage. The second part also says that it should be a sale which would become void on the payment of money. So, in both the cases, okay, that means if party has, party means here the mortgagor has not given the loan amount, then sale will take into effect, and if the mortgagor has paid the amount, then property will come back to the seller. Okay. Then it will be a sale which would become void on the payment of money. So, it is going to become void and property will come back to the this one mortgagor. So, this is another eventuality provided when there is a sale deed which incorporates in itself a condition that on payment of amount agreed between the parties, buyer shall re-transfer the property to the seller. That will also fall under the category of mortgage by conditional sale. That means, the sale has happened, but one condition has been given. Okay, one condition has been given that once I will pay the money, then you will have to transfer my property. Okay. So, here there are the you can see in these conditions there are degree or varying. Degree means degree of sale itself varying. Here suppose it is not paid in the third category in the case of retransfer, then you can find that it is already a kind of sale. Okay. What is saying that if provided where the sale deed which incorporate itself a condition none on amount of on payment of amount agreed between the party, the buyer shall retransfer. That means, if it will be not paid, then there is no requirement of retransfer. That means, it is kind of sale, it will remain. Okay. So, if parties are saying that no, I want a retransfer condition, then that will be called as mortgage by conditional sale. So, ostensible sale means a sale which apparently looks like a sale, but in reality it is not a sale, but a security for debt, because ownership is not completely transferred, because absolute transfer of ownership has not been done. Then next is this next point in this is that the mortgage by conditional sale is an ostensible sale which repents only on the breach of condition as to the payment into the an absolute sale. That means, you can say that it is just a prior stage of sale, that if the transferor, that is the mortgagor, is not paying the amount, then it will by default convert into sale. Okay. So, it is just nearer to sale, only one condition which will break, and that itself it will convert into sale. The mortgagor here has no personal liability. Why not personal liability? Because already it is protected through this conditional sale. Okay. The mortgagee remains content with the mortgage property only. Okay. Remains content with the mortgage property only. On the breach of the condition of the payment, the contract execute itself and become one of the absolute sale, which can be enforced in the particular manner known as foreclosure. Clear? Then next is difference between conditional sale and sale with condition of repurchase. What is the difference? Because it looks like similar thing. Okay. That one is conditional sale and sale with the condition of repurchase. So, it has been said that both looks like same, but there are difference between these, because this conditional sale is not transferring the ownership. So, in a mortgage by conditional sale, relationship of debtor and creditor is necessary. Someone is giving loan and there is a mortgage of the property. So, there is existence of debt is must, but in case of sale with condition of repurchase, there is no existence of debtor and creditor, and there is no requirement of any loan. Okay. So, there is no existence of any loan in case of sale with condition of repurchase. Then second is that in case of mortgage by conditional sale, there is transfer of only some interest in the property mortgaged, but sale by condition of repurchase, there will be the whole transfer of the ownership in that, okay, except a personal right to repurchase the property which is lost if it is not exercised within a given time. Okay. So, here also it has been said that in case of mortgage by conditional sale, only the limited interest is transferred, but in case of sale with condition of repurchase, it is already completely transferred. Only condition is that within a stipulated time there may be the repurchase of the property. So, the Supreme Court decides this question in Chunchun Jha versus Sheikh Ibadat Ali. Okay. What the Supreme Court has says that if the sale and agreement to repurchase are embodied in separate documents, then the transaction cannot be mortgage, whether the documents are contemporaneously executed or not. But the converse does not hold good. That is to say, the mere fact that there is only one document does not necessarily mean that it must be a mortgage and cannot be a sale. Okay. So, it is very clear, it has court has said that sale and agreement to repurchase, they may be embodied in different documents, then transaction cannot be a mortgage at all. But if both are in the same document, then there may be possibility of mortgage. Okay. And Supreme Court further held that whether the transaction contained in the document amounts to an absolute sale with an agreement to repurchase or mortgage by conditional sale must depend on the intention of the parties, which must be ascertained from the surrounding circumstances. Okay. So, in all this, importance has been given that in conditional sale or this repurchase, that what are the circumstances, how it has been drafted. Then third is usufructuary mortgage. Okay. It is also very interesting concept of mortgage, usufructuary mortgage, where it has been defined under 58D. Act or provision of the Act says that where the mortgagor deliver possessions or bind himself expressly or impliedly, implications, to deliver possession of the mortgage property to the mortgagee and authorize him to retain such possession until the payment of mortgage money and receive the rents and profits accruing from the property, and to appropriate the same in lieu of interest or in payment or mortgage money or party in both, the transaction is called usufructuary mortgage and mortgagee is a usufructuary mortgagee. So, in this usufructuary mortgage is that mortgage, that means there will be transfer of the possession of immovable property, a specific immovable property, and mortgagee will enjoy the all benefit of the mortgaged property till the completion of debt or amount is not going to be paid. That means, he will take all the benefits of the property, okay, and he will enjoy the, meaning thereby he will enjoy the full rights over the property subject to the return of the loan amount. Okay. That is called usufructuary mortgage. So, essential element of usufructuary mortgage are first, delivery of possession itself to the mortgagee, an express or implied undertaking of the mortgagor to deliver such possession, retention of the possession of the property by the mortgagee till the payment of the loan, okay, and receive all the profits, rents and all through that, either in lieu of interest on the mortgage money or in payment of the mortgage money. Okay. And there is no personal liability of the mortgagor. There is no personal liability of the mortgagor here. Only thing is that whenever he will return the loan amount, then only the mortgage will return the possession to the mortgagor. Okay. Mortgagee cannot foreclose or sue for the sale of mortgage property. This is interesting one here is that mortgagee cannot start the foreclosure proceeding. Only he is entitled that he will use the land, he will use the specific immovable property and he will take the benefit from that, but he will not start the foreclosure proceeding, or he cannot sue for the sale of mortgage property in usufructuary mortgage. The mortgagor is entitled to redeem the property when the amount due is personally paid and the debt is discharged by rents and profit received by the mortgagee. Okay. Then he can take the property after redemption. No time limit is fixed for the repayment. The best part is that there will be no time limit. Only thing is that you will, that is mortgagee will enjoy the rights on the property and will take the all benefits of the property. Where the mortgage is for 100 or more rupees, it must be registered, but where it is less than 100, it may be registered by deed or by delivery of property, that is possession. The same rule of sale will apply here. Usufructuary mortgage is not personally, here it is saying that in usufructuary mortgage, mortgagor is not personally liable for the mortgage money. So, the mortgagee cannot sue the mortgagor personally for his debt. Then mortgagee can only retain possession of the property, nothing else. He cannot compel the mortgagor that please return the loan amount, otherwise I am going to sell. This kind of the things does not happen in the case of usufructuary mortgage. So, right of foreclosure or sale is not available and mortgagor is entitled to take back the mortgage property from the possession of the mortgagee only on the payment of debt. The main characteristic of usufructuary mortgage is that no time limit. Now, come to the English mortgage. Okay. English mortgage, that is section 58E. English mortgage means what here? Okay. That it says that where the mortgagor bind himself to repay the mortgage money on a certain date and transfer the mortgage property absolutely to the mortgagee on a condition that he will retransfer it to the mortgagor upon payment of the mortgage money as agreed, transaction is called English mortgage. Okay. That means, here in case of English mortgage, what is going to happen, that property is going to be absolutely transferred. Okay. The transfer the mortgage property absolutely to the mortgagee, with a condition of the retransfer it to the mortgagor upon payment of the mortgage money. So, agreed, that it is called English mortgage. Okay. And mortgagee is called English mortgagee. What are essential of this? Essential is absolute transfer of the property. Okay. Absolute transfer of the property to the mortgagee. Unless and until there is no absolute transfer, and what is the meaning of absolute transfer? That means it is all rights related to that property has been transferred. That means it is a kind of sale. Okay. It is a kind of sale. That means, but here it is condition is that once the loan amount will be paid, then there will be repurchase, because in sale it may not happen. Okay. In sale no one can put this type of the condition. If this condition will be put in sale, then that will be void. Okay. Because sale is absolute transfer without any condition. Whereas, in case of English mortgage, there is a absolute transfer of property, there is a delivery of possession, okay, and there is a personal covenant to pay the amount. There is a personal covenant restriction that I will pay this amount whatever you are giving as a loan, because here the amount is not a price, here amount is in the form of loan and the person is taking that loan against that property what he is transferring and putting a condition over that property that whenever I will have money, then I will take it back and you will have to retransfer it to me, because that will be mentioned in the mortgage deed itself. Okay. So, there is no case to deny it by the mortgagee later on that he will not retransfer, because this is known since the beginning that intention of the parties are very clear, and especially here is the buyer, sorry, seller, where we can say it is a mortgager here. Mortgager intention is very clear that he is not selling his property absolutely for under the contract of sale, but he is transferring the property under mortgage against that loan amount, which will be paid by him later on, and there will be transfer of that property by the mortgagee to the mortgager. Okay. Then it will be a kind of English mortgage. So, property is transferred on the condition that the transferee, that mortgagee will retransfer it to the mortgager on the payment of mortgage money. So, intention is very clear. So, there should not be any confusion on the part of the mortgager and mortgagee, and you know that in sale intention matters. So, if intention, because you cannot, no one can say that it is a sale, it is only be treated as English mortgage, not as a sale, because there was no intention to transfer it as under sale, but keep it under the mortgage, and there was no such kind of the amount which will fall under the category of price, but it will only fall under the category of loan amount, and against that it was a security. This section also says that English mortgage, the mortgager absolutely transfer the property to the mortgagee. However, an absolute transfer can never be a mortgage, because in mortgage there is a transfer of limited interest only for securing the debt. So, use of the word absolutely is only a matter of form and not of substance. Only an interest in the property is transferred and not the whole property is transferred. Only an interest in the property is transferred and not the whole property is transferred. So, this absolute matter which is going to be transferred, that this stipulation within the mortgage deed that I am going to take it back, it will not make absolute transfer. Okay. So, property is going absolutely to the mortgagee, but transfer itself is not absolute due to that condition. Okay. So, it cannot be called as a sale. So, difference between English mortgage and simple mortgage. In English mortgage, property is transferred absolutely to the mortgagee. In simple mortgage, only the right of sale is transferred. Okay. In case of English mortgage, mortgagee has a right to enter into immediate possession of the mortgage property. In case of simple mortgage, mortgagee here has no right to enter into possession of the mortgage property. In certain cases, an English mortgagee has a right to sell without an intervention of the court. Okay. In simple mortgage, it cannot happen at all, does not have the right of sale without intervention. Okay. So, in that case, simple mortgage, sorry, in case of English mortgage, right of sale may happen even without the intervention of the court. Now, the second last mortgage, that is mortgage by deposit of title deed. Okay. Mortgage by deposit of title deed is known as equitable mortgage, and according to subsection F of 58, which says that where a person in the town of Kolkata, Madras, Bombay and in any other town specified by the state government concerned in this behalf delivered to a creditor or his agent document of title to a movable property with intent to create a security thereon, such a transaction is called mortgage by deposit title deeds. Okay. Mortgage by deposit title deeds. So, this is very clear that whatever amount, whatever loan is going to be taken, that is against the title deed of the mortgaged property. Okay. So, in this condition, it has been said that this is a special kind of mortgage, because here the execution of mortgage deed is not necessary. Execution of mortgage deed is not necessary. Mere deposit of title deeds of an immovable property by mortgagor to mortgage is sufficient. Essential element of this mortgage is there must be a date, there must be a deposit of title deeds, and this date must be secured by deposit of title deeds. Okay. So, these days most of the housing loans are based on this only, mortgage by deposit of the title deeds. That means, whoever is taking home loan, that means the home property ownership, that is title deed, is kept by the bank, and against that title bank used to give owner this loan to the owner of the house. Okay. So, it is in the form of mortgage by deposit of title deeds in case of mostly housing loans. Once the owner is going to complete the loan, then bank used to return that title deed to the buyer of the home, okay, or owner of the home. Then mortgage by deposit of title deeds, further it says that no mortgage is created where the documents show no kinds of title. A copy is not a document of the title, a deposit cannot be equitable mortgage. So, the original title, where the original title deed is lost, an equitable mortgage can still be created, and in order to create valid equitable mortgage, it is not necessary that all documents of the property should be deposited, but those documents by which the good title can be ascertained, that is sufficient. Last mortgage is an anomalous mortgage, and it is by name itself, it is very clear. Under 58G, it says that if the mortgage is not simple, mortgage by conditional sale, or usufructuary mortgage, or English mortgage, or mortgage by deposit of title deed, that means any mortgage is not mortgage which is not falling in any category, these 5 category, then that will be called as anomalous mortgage, a mortgage which does not fall under this category. Example of such mortgage includes Konam, Otti, and Pirwarth mortgage of Madras, and the San mortgage of Gujarat. Examples may be like combination of simple mortgage and usufructuary mortgage, combination of mortgage usufructuary by conditional sale, or some customary mortgages may fall under the category of anomalous mortgage under section 58. So, it is all about mortgage and its kind. So, this is all about this. Thank you all, and in next class, in next lecture, I will discuss rights and duties of mortgagor and mortgagees. Thank you.